Are you married in community of property? If you are, you can switch off now. But if you are married out of community of property, and if you're thinking of getting married, you'll want to keep listening. Hi, I'm Simon Dippenaar and I'm a family lawyer. When you get married in South Africa, you have a choice of matrimonial regimes. You either marry in community of property, which means all your assets acquired before or after the marriage form a joint estate, which is divided equally should you ever divorce. Historically, this was the standard marital regime and is still the most common. Unless you draft an antenuptial contract or ANC, your marriage is automatically in community of property. The other option is marriage out of community of property governed by the ANC. There are two types of ANC, one that maintains a complete separation and the other that keeps all assets and liabilities owned before the marriage separate, but allows an equal share of asset growth during the marriage. The latter is called with accrual, and it means that everything acquired after the marriage is considered part of the joint estate to be divided equally in the event of divorce. This includes any increase in the net value of each estate. This prevents inequality, particularly in the case of a spouse who gives up paid employment to look after children who earns less than the other spouse. On divorce, there can be a significant disparity of personal wealth. This inequality is remedied by the accrual system. Complete separation of property without this adjustment is known as marriage out of community of property without accrual. In this case, all property owned prior to the marriage and all property acquired during the marriage belongs to the person who acquired it. Couples who choose this regime might be entrepreneurs, professionals, or people with inheritances they want to safeguard. If one or both partners owns a business, they may want to keep their business assets separate from marital assets to protect the business in case of a divorce. And some people, particularly later in life, simply prefer to maintain financial independence. However, a recent judgment in the North Gauteng High Court challenges the irrevocable nature of the without accrual system and the legal framework governing divorce in South Africa. The High Court found Section 7, subsection 3A of the Divorce Act 70 of 1979 inconsistent with the Constitution and unlawful. The Greyling case involved a wife who challenged the legality of a provision within the Divorce Act. She and her husband were married in 1988 with an ANC which excluded the accrual system. Her father-in-law-to-be provided advice on the terms of the ANC. During the marriage, the wife dedicated herself to raising their children, managing a farm, and engaging in community service. Meanwhile, her husband prospered as a successful farmer. The couple started divorce proceedings in 2016. The main issue before the court was the constitutional validity of denying spouses access to certain provisions of the Divorce Act if they were married out of community or property without accrual. The case hinged on the fact that a spouse's fundamental human dignity is impaired when no recognition is given to their contribution to the increase in their spouse's estate during the marriage. The court challenged the principle of freedom of contract by declaring Section 7.3a of the Divorce Act unconstitutional because it restricts the application of just and equitable remedies for spouses. The case raised questions about the enforceability of ANCs and questioned the ability of parties to make informed decisions when entering into such arrangements. The wife in this instance was advised by a future father-in-law. How objective was that advice? To what extent do individuals fully comprehend the implications of their choices when agreeing to terms that may impact their future rights? Legal practitioners, myself included, may need to reassess their strategies and advice in light of the changes to our legal framework. In future divorce cases, courts will have to assess the ability of each spouse to generate income, consider factors such as educational level, skills and knowledge, as well as employment opportunities. The financial needs of each spouse, including ongoing expenses and lifestyle requirements, will be taken into consideration to ensure a fair outcome. Contributions made by each spouse to the marriage, both financial and non-financial, will be evaluated, including child care, career sacrifices, and support for the other spouse's professional endeavors. The length of the marriage may also impact the court's decision, as longer marriages typically involve more intertwined financial affairs. Lastly, the court may consider the future prospects of each spouse, including potential for career advancement, health concerns, and financial stability. This equitable approach in divorce proceedings ensures that lower earning or non-earning spouses are not unfairly disadvantaged and the contributions of both parties are taken into account regardless of the matrimonial regime. This will ensure a fair distribution of assets upon the dissolution of a marriage. However, it does call into question the role of marriage out of community or property without accrual. An ANC defining this arrangement may become a guideline rather than a legally binding contract. If you're considering marriage, I can help you decide which type of marriage is best for you and draft an ANC appropriate for your circumstances. If you are married out of community of property without accrual and would like to review your circumstances, it is possible to change the regime you selected by, for example, drafting a post-nuptial contract. I can help with that. Give me a call or send a WhatsApp on the number below.